I'm Alexandra Durazo, and this presentation is on LGBT workplace discrimination. Millions of Americans wake up every morning and go to work with the awareness that they could lose their job not because of anything they do or fail to do, but because of who they are, lesbian, gay, bisexual, or transgender. Employment discrimination based on sexual orientation and sexual identity is only protected under non-discrimination laws in 18 states. Why do we need non-discrimination laws? 42% of lesbian, gay, bisexual, or transgender workers have experienced being fired, denied promotions, or harassed according to the William Institute at UCLA School of Law. An estimated 78% of transgender employees have experienced harassment or mistreatment at work due to their gender identity, with some studies reporting even higher numbers. Most Americans think LGBT employees are already protected under Title VII. A study showed that 8 out of 10 voters falsely believe that federal employment non-discrimination protections already exist for lesbian, gay, bisexual, and transgender individuals. Title VII of the Civil Rights Act of 1964 prohibits discrimination in the hiring process, discipline procedures, discharge, promotion, and benefits. This act protects discrimination based on race, color, national origin, religion, sex, and pregnancy, so it makes sense that most Americans believe these individuals are already protected. The Equal Employment Opportunity Commission monitors compliance with Title VII. An employee alleging discrimination must file a claim with the EEOC before a lawsuit can be brought against the employer. In 2012, the Equal Employment Opportunity Commission held that discrimination against an individual because that person is transgender, also known as gender identity discrimination, is discrimination because of sex and therefore is prohibited under Title VII of the Civil Rights Act of 1964. The Commission's Strategic Enforcement Plan, adopted by a bipartisan vote in December of 2012, lists coverage of lesbian, gay, bisexual, and transgender individuals under Title VII's sex discrimination provisions as an enforcement priority for 2013 through 2016. This enforcement priority is consistent with positions the Commission has taken in recent years regarding the intersection of LGBT-related discrimination and Title VII's prohibition on sex discrimination. On July 21, 2014, President Barack Obama signed an executive order regarding further amendments to protect LGBT employees from workplace discrimination.
In a few moments, I will sign an executive order that does two things. First, the federal government already prohibits employment discrimination on the basis of sexual orientation. Once I sign this order, the same will be explicitly true for gender identity. And second, we're going to prohibit all companies that receive a contract from the federal government from discriminating against their LGBT employees.
Because of this executive order, lesbian, gay, bisexual, and transgender citizens employed by federal contractors across the country will now receive legal protections designed to ensure they are judged by the quality of their work, not who they are or who they love. I chose to focus on the Employment Non-Discrimination Act, which prohibits discrimination in hiring and employment on the basis of sexual orientation or gender identity. This act has been introduced in every Congress since 1994, except the 109th. On November 7, 2013, the bill passed the Senate with a vote of 61 to 30. There was supposed to be a vote by the House of Representatives the following year, but the House has yet to vote.
Should be discriminated against because of race, sex, religion, national origin, and they shouldn't be discriminated against because of who they love or who they are or whether they're gay, lesbian, bisexual, or transgendered.
It's called the Employment Non-Discrimination Act, the legislation that prohibits workplace discrimination against gay, bisexual, and transgender Americans. It cleared its first big hurdle on Monday. Senate lawmakers voted in favor of the bill by a large margin.
The ayes are 61, the nays are 30. The motion is agreed to.
This was first introduced as the Equality Act, which would have amended the Civil Rights Act of 1964 to include sexual orientation under the protected classes. In September of 1996, the Employment Non-Discrimination Act was closest to being put through the Senate but failed by a vote of 49 to 50. This act does have a religious exception. The exception consists of 3 parts: a complete exemption for houses of worship, parochial and similar religious schools and missions, a codification of the so-called ministerial exemption, recognized by many federal courts exempting positions at religious organizations that involve the teaching or spreading religion, religious governance, or the supervision of individuals engaged in these activities, and a provision allowing religious organizations or classes of jobs to require employees and applicants to conform to a declared set of significant religious tenets, including ones that would bar LGBT individuals from holding that position. I think the Employment Non-Discrimination Act should be passed and will help in more ways than one. There is no federal law that consistently protects LGBT individuals from employment discrimination. As a result, LGBT citizens face serious discrimination in employment. There is also plenty of public support. More than 2/3 of voters, including a strong majority of Republicans, support a federal law protecting LGBT citizens from discrimination in the workplace, according to a September 2013 poll by Republican pollster Alex Landry. Majorities in each of the 50 states, according to a statistical modeling, are on board. Hundreds of companies have enacted policies protecting their lesbian, gay, bisexual, and transgender employees. House Speaker John Bonner, who opposes the Employment Non-Discrimination Act, released a statement saying that the ENDA will increase frivolous litigation and cost American jobs, especially small business jobs. However, studies by the U.S. Government Accountability Office in 2002 and 2013 completed in states that already have employment protections for LGBT individuals have not seen any notable increase in litigation. As for business, years of research and analysis show businesses support workplace protection for LGBT employees and believe them to be good for their business. As of April 2013, 434 of the Fortune 500 companies had implemented non-discrimination policies that include sexual orientation, and 282 had policies that include gender identity. An analysis done by the Williams Institute at UCLA School of Law shows that in extending these protections, companies cite associated benefits for their business, including improved recruitment and retention, innovation resulting from a diverse workforce, and attracting a wide range of customers, among other positive business outcomes. Small business owners are also in support. A poll conducted by Small Business Majority found that 67% of small business owners favor federal legislation protecting gay and transgender individuals from employment discrimination. In fact, 7 out of 10 small businesses prohibit discrimination on the basis of sexual orientation, and 6 out of 10 small businesses already prohibit discrimination on the basis of gender identity. LGBT workers who have been allowed to live authentic lives without fear of discrimination report higher workplace satisfaction, job commitment, and increased productivity and output. Ken Charles, Vice President of Global Diversity, explained why.
Could you be engaged, productive, effective if you lived in fear? Fear of losing your job, being denied a promotion, being harassed or bullied on the job? For many qualified, hardworking Americans, this is their experience because they lack the basic protection of a consistent federal law.
Current protections are a patchwork of various state and local laws and court and administrative rulings that offer inconsistent guidance to employers and protections for workers. These varying degrees of protections create confusion for both employees and employers. A uniform federal standard would simplify and clarify the work protections afforded to LGBT Americans while ensuring that all workers are judged on their talent, work ethic, and merits. In conclusion, workplace protections exist to ensure that all Americans will have equal opportunity to provide for themselves and their families. While it is against the law to fire someone because of their skin color, or to refuse to hire someone because of their gender, or to harass someone in the workplace because of their religion, there is no federal law that protects LGBT individuals from those forms of workplace discrimination. Employers should be focused on an employee's work ethic and qualifications, not their private lives.